A very good evening, ladies and gentlemen. Honorable Datuk Justice Lee, Dr. Christopher To, friends of AALCO, welcome. Tonight's Fireside Chat, we feature the very distinguished Honorable Datuk Justice Lee, who came all the way from Malaysia. Please join me to give him a big hand of welcome, applause. Honorable Justice Datuk Lee was head of the Specialized Court Construction Court in Malaysia, and he's been a very distinguished, long-serving professional in our field. Called to be a lawyer in 1985, and so been a little while, lots of experience to share. And since in Hong Kong, if you don't mind, we have our friends here from the government, from the Development Bureau. Hong Kong, we passed the law in December last year, but to take effect in August 28th this year. So we are very eager to learn from the wise friends from Malaysia. In Malaysia, there's a dispute resolution center called AIAC. AIAC stands for Asia International Arbitration Center. It's the busiest center for dispute resolution in Malaysia, and they are our friend, our sister organization of AALCO. So friends here, many of you know AALCO stands for Asia African Legal Consultative Organization, set up in 1956, and now we have let's see, 49 member countries. So together we want to advance economies around the world, and to advance economies we realize we have to have a way to resolve disputes and prevent them, and ways to solve problems. So apart from solving human rights issues, digital economy issues, law of the sea issues, one of the things we identify is to help with infrastructure development. And in Malaysia, they've done a really great job. And so we're here to learn from our sister organization and our sister brothers from Malaysia. To Datuk's left is Dr. Christopher To. Very little introduction. Yay! So here you would call him professor, friend, teacher, brother. He's known to many of us. He was the Secretary General of Hong Kong IC. He recently also helped us as a lead coach for our sports disputes resolution program at AALCO. Also offers AALCO Distinguished Arbitrator and Mediator. He at Hong Kong Institute of Engineers at the time, I think I just learned you were leading efforts in wanting this to happen, to resolve problems with payments in the construction industry. So today, it's a fireside chat. I will start with some questions, and then maybe I will open the floor, invite you all to share some thoughts. Today in this room, we have engineer, we have surveyor, we have lawyers, we have financiers, we have bankers, and people from different walks of life. Some very senior construction lawyers in the industry. So please share your thoughts. I don't have a particular agenda except to use this opportunity for us to get together to learn from each other, best practices, what we should expect after August 20, or more like how we should prepare for it, how we can do better. So on the screen, Jolie will show us. I'll sit down now from now on. So on the screen, it's just a quick selection of some of the recent news, not happy news. This is about some of the construction cases met with some financial difficulty or not, because workers not getting paid. So why are workers not getting paid? Why are the projects being stalled? There are different explanations, different excuses, different reasons being given. But how can we solve it? With the new law, there will be a nominating body. We'll soon find out how many more there would be, but there are nominating bodies of adjudicators. So if you're in this room or if you're joining us online as well, thank you and welcome. Can you be an adjudicator and help out? Who should be the nominating body? And how can we do better as nominating bodies? If you're a financier or using technology, and how do you solve the problem? Do you smart contract? Or does the law itself solve all the problem? It may or may not. So let's hear it. I mentioned earlier, Justice Datuk Lee headed the construction court, the specialist court in Malaysia. Do we have a similar court here, Danny? question for a construction lawyer? We don't, right? So why do you have it there? Over to you. Chime in anytime. Thank you.
First of all, let me thank AALCO Hong Kong Regional Arbitration Centre, represented by its director, Mr. Nick Chan, for giving me this opportunity to address such a distinguished audience, people who are key players in the construction industry in Hong Kong. We have had some experience with construction adjudication, and we thought a little bit of sharing would help. There is an old English saying that the early bird catches the worm, but there is also the other saying, which is that the second mouse gets the cheese. So
Didn't know that.
the fact that you're first in point of time doesn't mean that you have all the problems resolved. There will be others coming behind you who learn from all the best practices in the world and formulate something that would really suit their particular culture and context. Now, as to why we have a construction court, I suppose that has to do with the question of specialization. Why do we specialize? So as knowledge grows and increases, we find that we have to choose between knowing more and more of less and less, that's specialization, or knowing less and less of more and more, all right? Can you get the difference? Knowing less and less of more and more are the generalists, whereas the specialist knows more and more of less and less. So a high court judge, for instance, might one day in a general court be hearing land acquisition case, tomorrow defamation, the third day dismissal from employment, the fourth day medical negligence, the fifth day breach of contract. So he's a little bit distracted. Not that he cannot do a good job, but compared to a field of law which requires some specialization, it would help if that particular judge hears nothing but everything about construction dispute. He can focus and go deeper into the law. He has all the precedents with him already, and he can develop the law much better in that sense.
Justice, how many cases do you actually have in the past 5 years, for example?
Well, in terms of cases that have come to the courts on construction law statutory adjudication, for the last 10 years, we had something like 500 over cases. And so if you divide by 10 each year, we have about 50 over cases or so, thereabout. 500
That
by
ended
10,
up in court.
Yes.
But then if
But this
didn't-
comes in triplets because when it comes to an adjudication decision, normally the losing party will file an application to set aside, the winning party will file an application to enforce, and the losing party not wanting to lose out will file an application for stay of the adjudication decision or the adjudication determination, as is the word used in your ordinance. So it comes in triplets.
But in Malaysia, you keep going up, right? You can keep appealing.
Yeah.
But in Hong Kong, do we do that? Have you?
In Hong Kong, I read that it goes to the court of first instance, and you need leave before it can go further. And I think that's a very good move.
Yeah.
Because you see, adjudication is just an interim measure. So if you allow people to exhaust through all the avenues of appeal, by which time the arbitration or litigation should have been concluded already. So there's really no need, looking back, to be able to take it to the highest apex court for an adjudication decision, perhaps.
Chris, would you like to share your thoughts?
Okay.
Thank you.
I totally agree what the judge has said. I think in a sense that people would say that Hong Kong is a bit slow. I disagree. Okay, I disagree simply because I agree with the judge that basically we are looking at a sort of holistic view in terms of how different jurisdictions are doing it. We've taken a long time to actually go through this process. I remember it started in 2007 when I first received a letter from the Hong Kong Construction Association complaining about how come people are not getting paid. At that time, my position was the executive director of the Construction Industry Council. And I raised this point with the then chairman, Keith Kerr, and I says, this is could be an issue because look at the facts, look at the issues. And he says, okay, let's table this in the council meeting. The meeting was in Murray Building. I remember very clearly. We had the Construction Association, at least 5 people there, including, for example, Thomas Ho, who's now the chairman of CICE, advocating that we should actually address this issue. So rather than take the Construction Industry Council's sort of association's views, we decided to actually move forward and actually do a study, which we did, and it came out very positive for legislation. And this study wasn't done by ourselves, it was done by Hong Kong U. And subsequent to that, we actually debated further. Some people had concerns about it, said, oh, we shouldn't be implementing this. So the government decided we should actually employ the Census and Statistics Department of the Hong Kong government to do another study, which we did with them together, and it came out positive again. So then subsequently, we had to address this going forward. And one of the community concerns was, wow, we existing owners might be basically penalized by this legislation. The Home Affairs Bureau came back and said, lots of people do not like this. So that's why it took a long time to convince them that only new buildings, not existing buildings of repair, maintenance and all that will be covered. Subsequently, this proposal was put forward and studied in detail by the Development Bureau. I can tell you the Development Bureau has not been sitting there doing nothing. Okay, most people say, wow, it took us so long. The Development Bureau has studied every single piece of legislation around the world and come up with different scenarios to address the concerns, particularly for Hong Kong. Okay? In Hong Kong, we tend to be lots of political issues. Why? There are many bodies out there who want to be nominating bodies. The chances are you can open the floodgates. But what happens is if you open the floodgates and anyone can be a nominating body, what will happen is the quality assurance would be a problem. Then consumers will lose confidence in the system. So they have to address this as well. So we have to have right quality adjudicators, right quality of systems in place, and so forth to move forward. So this whole process, even though we are slow in Hong Kong, but we are trying to fine-tune it so that when we deliver the product, or when the government delivers the product, it will be a product that people can accept, trust, and use going forward. And I was an advocate of this for the very start, even when Hong Kong CA came in. I truly believe that this is a good system, but it took a long time. But I'm delighted now, after how many years? 20-odd years, it's now in place. Okay? And hopefully by August the 28th, 2025, we should see this legislation come into fruition.
I think now we're cutting beyond politics, if there were any, to try to work together. I think there are members from Hong Kong IS, Hong Kong IA, Hong Kong IE, and Law Society Bar in the room. So we could deal with it here, couldn't we? And friends from online, I know Hong Kong IA is online. So what's next? Or maybe just to look at, you've had the law in Malaysia for some time. What are the learnings, experience that you could guide us in our thoughts?
No legislation is perfect, and that's why you need the courts. The courts will come in to kind of fill in the gaps where perhaps certain problems have not been anticipated or thought about. So in our contracts, for instance, the way we define construction contracts and construction consultancy contracts, some of you might want to refer to your own definition and ask the question, does it apply to those construction works with respect to the oil and gas industry or with respect to the shipping industry? So perhaps it may not be very clear. And so certain things we have to kind of thrash it out through judge-made law. So one of the matters that came before me was an old ship that was transformed into FSOP. They call it the floating submersible offloading and storage platform with respect to oil drilling and exploration. So there was the issue of valves being used for some of the gas pipelines. And so the question was whether that contract is a construction contract. So we interpret the law. Then the other issue that has come out is whether a claim for loss and expense is actually a claim that is adjudicatable under a construction contract. So if you look at your definition of payment claim, it is said to be a payment claim is a claim for a progress claim for work done. And so, but loss and expense is also work done. Is it more of an expense or is it loss, which is a kind of damages claim? And so some jurisdiction has spelled it out very clearly. In our jurisdiction, I've held that if what is claimed under loss and expense is added to the contract sum to form part of the total contract sum of the contract, then I see no reason why it couldn't be adjudicatable. But you have to look into your own definition with respect to whether or not legislature had intended a loss and expense claim to be part of a claim that could go for statutory construction adjudication. Then it comes to the meaning of conditional contract. Okay? So a pay when paid contract is of course prohibited under your ordinance, so it is in ours. But what if there are certain conditions like this, and we have in one of the standard form contracts by a professional body a clause to the effect that if you have been terminated by the employer, then any payment that is due but not paid, or any payment not due yet, will not be paid until the final accounts is prepared after the completion of the project. So is that a conditional payment clause? And so we have to interpret it. To me, I took into consideration the fact that CIPAA, our Construction Industry Payment and Adjudication Act, was designed to facilitate payment. And so such a term in the contract would be a conditional payment clause that we think the legislature prohibits, because it has that chilling effect of preventing payment from being paid out to a contractor who has done the work. Doesn't matter whether or not the termination was lawful or unlawful. Meanwhile, his workers have to be paid, his family has to be fed, his suppliers have to be paid, etc. So that's how the court has to come in to sometimes interpret some clauses that are not perfectly clear. But then there could be other conditions which you think might be good. So some conditions would be an employer is concerned that if he pays the main con might not be paying the subcon and the other workers. And so some contractors or some contracts would have a clause to say that employer shall not make further payments to the main con until the main con has sworn a statutory declaration that all outstanding payments to subcontractors have been paid. In that sense, it's a conditional payment clause. But for good governance, we say hallelujah to that, because it's good. Because if finally the person that does the work is not paid, he will be dumping his tools, he will be working slowly, there will be no motivation, he will cut corners, etc. So it all depends on what kind of conditional payment clause. So you have a term that says any contract or any term of a contract that defeats the purpose of the ordinance, or that is opposed or in conflict with the terms of the ordinance is null and void. That's a very good thing. We don't have it expressly stated in our act, but we think our act should be interpreted in that way as well. So it all depends on how you're going to interpret what is meant by a conditional payment clause. Is it confined to pay when paid, or does it go beyond that? So that's where you need the courts to come in to help expound the law, as it were, to clarify it, and to make it more certain for people who are really caught in a dispute with respect to the terms of certain clauses within your ordinance.
For some friends who's not deeply engaged in the construction industry, what is pay when paid? What does that mean? And what are we trying to address with this law?
I think what happens is that if you look at it from this angle, the employer, main contractor, and subcontractor. In the contract,
the principal.
So if we call it principal, main, and also the
prime
subcontractor, whatever. So you can see, for example, this main contractor and the subcontractor will have a contract, whereby saying, for example, if I don't get paid by the employer, basically you will not get paid.
Often a big construction company or the government even sometimes.
Yes, okay. So in a way, if they pay me, I'll pay you.
Sounds fair.
It sounds fair, but also there could be lots of issues about, for example, the quality of the work, lots of arguments. So if they don't pay and withhold payment, then the subcontractor will not get paid. And it's the diagrams you've shown on the screen.
Yes.
The workers eventually will not get paid as well. So this is not very good for the industry. So
and for the economy.
Economy. So you have two different separate contracts. So if you, as a main contractor, enter into a contract with subcontractor, you should be responsible to subcontractor for payment if they've delivered the goods or services.
So as lawyers in this room or online, if you are going to draft contracts that take effect after 28th of August this year, and you draft basically a pay when paid clause, and not knowing that the law would now override it in some way, then could be some law society issues.
So that's why it's very important. I think many law firms in Hong Kong and many solicitors here have
Yes.
written newsletters
Yes.
about, for example, some of the precautions that you have to be aware of. And one of the areas you have to be aware of, as Nick mentioned, is the pay when pay clauses provisions that you have to review your contract and try to amend it to actually eliminate that provision so that you do not fall foul of the legislation. If not, you could be in deep trouble, and there could be claims against you as a solicitor, or even, for example, as basically a person who drafted the contract as well.
Justice Lee, from the at least the Malaysian law, you could talk about Hong Kong as well if you like. What are the tests of something that is substantiate? This is pay when paid. Is there like a checklist, a test? From case law, from the law
That's right.
itself.
Under our Construction Industry Payment and Adjudication Act, we have a definition for payment. Payment is defined as payment for work done or services rendered. In your case, your definition is respect to a payment claim. A payment claim is a claim based on a progress, a claim invoiced or claim made for work done, I think. Yeah. Now, in our case, people have come up and says, look here, contractor is making a claim against me as the employer. Can I not counterclaim for a bigger sum? Oh, interesting question, isn't it? And so we have one case where even the contractor, the main con, went for adjudication. At the end of the day, the adjudicator says the counterclaim of the employer is much bigger than the main con's claim, and actually awarded an adjudication decision or determination in favor of the employer. Then it came before us for setting aside. And so we have to look into the statute. And so we begin by asking, what is the meaning of payment? Payment claim is a claim for work done or services rendered. So has the claimant, who is the main con, done work? Apparently so. Now, what are the defenses and counterclaim of the employer? Employer says there were defective works. We asked you to rectify the defects. You didn't. We engage another contractor to do it. It's double or triple that rate. And then there was delay on your part, and so we slapped you with liquidated and ascertained damages, and that's much more than your claim against us. And so finally, we are using this statute. In your case, it's the Construction Security of Payment Ordinance to slap you with a higher claim. And so this ordinance itself is meant for both the contractor who did the work as well as the employer who suffers because of the contractor's delay in doing the work, as well as the defects attributed to the main contractor. So it came before us, and we tell ourselves this. The most that an employer can do is to raise a defense in the kind of a set-off, which completely zeroizes the claimant's claim. The act or the ordinance in your case was not designed for an employer to make a claim for damages. It is a claim for work done. So a damages claim is a different claim altogether. An LAD claim is a claim for losses, it's a claim for damages. It doesn't fall within our understanding of our act or perhaps even your ordinance. The most is you get nothing, except you have to pay costs if you lose in the adjudication, but it won't end up with, at that stage, you having to pay your employer a certain sum of money, which is the assessment of the losses. So that's how we interpret it. Perhaps it will come before your courts too. I'm not too sure.
I think that's the beauty of a common law system because we actually have a statute, just like in Malaysia. The statute cannot cover every single scenario. It's impossible. The chances are then we have judge-made law who actually supplement it as well. So that's why this is very good in the sense that we have this system in place. Now, our system is slightly different from Malaysia in certain contexts. If you look at the legislation, I think one law firm did a comparison. If you go to the website, you'll find it. I won't go into each provision. They've gone in, done a comparison of different jurisdictions. And ours is quite similar to some of the common law jurisdictions around the world, but with some modifications. And but one of the things that we in Hong Kong are concerned, especially I'm concerned, is the quality of the adjudicator's decision. Because we have people who are non-lawyers and people who are lawyers. Now, some of the lawyers, okay, I'm sure that you've heard of an sort of a talk done by Doug Jones recently, Professor Doug Jones in the GAR seminar. He said that lawyers need to understand what damages and how damages are assessed. And I take that very strongly because I've sat in cases whereby some lawyers do not really understand the concept of how experts come up with the damage calculations. And when they make a decision, they just base on general context. But if you look at how the experts, the surveyors, come about calculations, if you know more thorough and more detail, you can actually get a better sort of decision-making process for the client. So I think this is something that we can learn from each other, that lawyers can learn from the technical people, and the technical people can learn from the lawyers as well. But that's why the Development Bureau is going to come up with some guidelines. These AMBs, appointing bodies, will have to comply with. And one of them is relating to, for example, decision-making, ethics, and also, for example, how the operation of the AMB works as well.
As we implement SOP in Hong Kong, another question for Chris, if I may. How do you anticipate this would change the landscape of people in the value chain, organizations in the construction industry? How should we prepare for the change?
I think now, looking at it from the lawyer's perspective, okay, I think that less cases will go to arbitration. Quite a lot of them will go to adjudication. So the number of cases going to sort of construction arbitration will decrease at least for the first 2 years. The number of cases going to adjudication will increase. Now, once they increase, they will stabilize to a certain extent because people will start to get to know the system. You can't dodge it anymore. You really have to go through the system. And also, many of the people have sort of a dispute resolution provisions in the contract. Some of them will try to use those, like, for example, mediation, negotiation, to resolve the dispute without even going into adjudication. So you can see the landscape will change from the legal perspective. From the non-legal perspective, it will change drastically in terms of how we do claims, because we'll have to sit down and work out with the main contractor and the subcontractor work together a payment schedule. And they have to agree a payment schedule, how the payments are paid, and so forth. They'll have to come much more detailed. And if someone has breached the payment schedule, that could be a trigger point for you to go into adjudication. So chances are you have to work very carefully on those timelines. And on top of that, for example, you have to work, for example, how you go about doing your claims. Okay, most people will not engage a lawyer at the very start because they'll say, oh, I'll just do it myself. Because usually most organizations will have standard template forms. The Hong Kong IS has a standard template form for a claim. Likewise, the engineers, and I'm sure that Hong Kong IA, I never looked at Hong Kong IA's webpage, but I looked at surveyors and engineers. They do have a standard template. You just fill in the blanks. Okay, so chances are filling in those blanks are important, especially one of the points that most people have to argue is whether there is a dispute. The key word is, if there's no dispute, how can you go through the adjudication process? So the key thing is you have to understand the crystallization of the dispute. Has it really happened? So you have to have from the start to finish, to explain how the dispute came about and whether there is a dispute that the other side has sort of argued on. If they haven't argued on it, there could be no dispute. So then the chances are the other side might go to court to set aside. There's lots of things that basically we are learning from Malaysia and learning from Singapore and also Australia, Ireland, and also United Kingdom in these areas.
Thank you.
Yeah.
Dr.
If I may just chip in.
Please
Nick,
do. Please do.
I think it's a fair question to ask. How many of the cases that go for adjudication actually are resolved there more or less fully and finally without the need to go for arbitration or litigation? So we looked at the statistics collected from AIAC, which is the administrative body for construction adjudication in Malaysia.
Only one body does it all.
We have one. I heard you all might have more than one. You can talk about that
Yes,
later.
yes.
So in the course of about 10 years or so, we have about 5,000 cases that were registered with AIAC for adjudication.
Okay.
Now, within that period of time, we have something like 500, or rather something like 2,000 cases that come before our courts.
Right.
But this comes in triplets because, as I say, a person not happy with the adjudication determination will apply to set aside. The other party will apply to enforce, and then the losing party may file a third application
So it might be double
to
counted,
stay.
triple counted.
So be generous. Let's say out of the 2,000 cases or so, 1/3 of them actually are more or less the same. It comes in triplets. So if we take that out of 2,000 and we divide it by 5,000 or so,
Okay.
we find that it yields an average of about 15% of the cases that went for adjudication actually ended up in the courts, whether by way of setting aside the arbitral award or actually the parties litigating it in court. So that's rough ballpark figure. And so if you look at how successful adjudication is in resolving disputes fully and finally, we can say about 15% in the Malaysian context of those cases will actually be fought out in arbitration or litigation. So in that sense, it gives us some hope that adjudication gives that kind of precursor towards resolution in full. And so out of an award or a decision that is in favor of the main con, the employer might sit down with the main con and says, I need to pay you this, all right, but you also need to pay me this for delay in completion, so can we not agree? And sometimes they could. So that's our take on the subject.
Do you also have statistics about of the 15% that went to court? How often does the judge uphold the decision of the adjudicator? Yeah.
Very fair question. When we look at the scheme of the Act as a whole and your ordinance, we find that there are very rare instances when an adjudication determination could be set aside by the court because the jurisprudence surrounding adjudication is this. So long as the adjudicator asks the right question, it doesn't matter if he gives the wrong answer, we won't set it aside because it is only of interim finality. If it's really, really unequivocally wrong, in our courts we use that language, or if the justice of the case demands it, then we may stay, whether conditionally or unconditionally. And so they say what is important is you ask the right question. And so when I first heard that, I was a little bit alarmed, you know. Don't tell me right answer is not important, right question important, how can it be, you know? Until I came across a quote by Steve Jobs. Steve Jobs once said this, if you ask the right question, you invariably find the right solution. And so asking the right question is very important. And if you are already an accredited adjudicator, I'm sure if you ask the right questions, you more or less get to the right answer. So that's the whole philosophy behind it. That's why we can say rough justice, because the perfect and refined one can come in the arbitration. But then for the moment, those who have done the work ought to be paid. And then we talk about pay first, and what do you call, litigate later. But sometimes people say it has become so complicated that now it is, argue first and then pay later. But it was meant to be pay first, you argue later.
So even the 15% before we know the decision, does it hold up the money or doesn't it?
Generally, the courts will not allow stay unless there are very good reasons. Some good reasons would be that company that you're supposed to pay to is in the brink of insolvency or his balance sheet is so bad. But if it's a case where his balance sheet had not deteriorated the time that you awarded him the contract to the time he is now claiming from you, then it's no good ground to say at that time not important to me, but now that I have to pay him, it's important to me. And so unless it is a clear and unequivocal error, you find that the court will not grant conditions for stay. The court would generally not grant stay at all.
First.
Pay first. And out of the cases that come for setting aside, we would say hardly 10% are set aside. Normally on ground of breach of natural justice. I'm glad that your ordinance used the word material breach of natural justice, which is, I think, much clearer.
You don't have material there.
We don't have material, but we still interpret it to be, it must be quite material.
Yes.
And then the other more common ground would be excess of jurisdiction. The matter is not within the jurisdiction of the adjudicator, but he went ahead to adjudicate on it. So these are the two main grounds. So only about 10% are being set aside. Correspondingly, only about 10% are refused enforcement. So 90% of the cases are enforceable, are in the courts of law, and you find arising out of that a whole new industry has grown up. A consultant adjudication claims industry. And I suppose Hong Kong people have been very enterprising. You will find a whole new group of people who call themselves construction adjudication consultants who will be helping with filing of the claims, advising on the claims, and going to court. Because they see court statistics in other jurisdictions, 90% successful. So some might even be prepared to go on a contingency basis. I don't know if that is allowed in your law or in Hong Kong.
No, not yet. Not for court.
Yeah. So it seems there's a difference between what we call conditional fee as well as contingency fee. One is disallowed, the other is quite okay. All right. So you asked Mr. Christopher Toh, what's the difference between contingency and conditional fees?
Now, last week I was approached by, I won't mention, quite a few engineers and surveyors. They're thinking of forming a company to actually do claims consultancy work. I don't mind doing pro bono stuff, but sometimes some of the claims I've done before tend to be not really too legalistic in nature. They tend to be just payment claims or issues about quality. So maybe this could be more suitable for those who are non-technical to address it. Plus, the judge said it very clearly, there's only two grounds. One is, for example, you exceeded your jurisdiction. The other one is natural justice. So if you do things properly, the chances are it's going to be not set aside. And that's why the Development Bureau plus the industry, the various four bodies, are now working together to provide some guidelines, what is proper in terms of ethics, jurisdiction, and all these kind of things, so that potential adjudicators will be able to actually know what is right, what is wrong, and when do you go past the borderline into a different area whereby you could be challenged. So I think we do have the courts, and also I think our judge, Mimi Chan, her honor, leadership, basically will look into this because she is in charge of the construction and arbitration list. So most of the cases will go to her. So,
and she's great.
And she knows construction in the sense that even though she was an M&A lawyer previously as a solicitor, but I think she's now knows about construction pretty well to understand some of the ins and outs of how things work in the construction industry. So I have confidence in her as a judge looking after this area.
A question for you both, or maybe first from Malaysian experience in Hong Kong. Adjudicators, mediators, arbitrators, judges, who should have immunity from being sued by parties? And who does at the moment has immunity?
Well, for judges, I think in most common law countries, you would have your relevant statute. For us, is the Courts of Judicature Act, where unless a judge acts mala fide or assumes jurisdiction that he totally doesn't have, which is so very obvious, then you can't sue a judge. The same is provided for with respect to immunity against arbitrators and adjudicators. So long as you do your work properly and that you have not disregarded totally the interests of the other parties. You hear both sides and you give your decision. Doesn't matter if your decision is wrong. Because if an adjudicator is exposed to being sued each time he gives a wrong decision, nobody dares to be an adjudicator.
Right.
They have to take up professional indemnity coverage. But not to worry. The same with mediator. We have a Mediation Act, and there is a section that provides for immunity with respect to acting as a mediator, unless, of course, you act mala fide and in total excess of your authority and do things that are not fathomable under your role, in your role as a mediator. But like all professionals, we are exposed to being sued if we should have acted negligently. And they say the most careful of us can sometimes miss on a very important point. And so we cover ourselves professionally so that our clients are not adversely affected. Should it be something that we have failed to advise our client on and it's found that we have been negligent. But as a judge, as an arbitrator, as an adjudicator, as a mediator, I think you can more or less sleep soundly with a clear conscience so long as you do your job properly. Of course, there are two other grounds for setting aside. One is a award or a determination that has been corruptly procured or there has been bribery, and the other is where you have been biased and you have not acted impartially or independently. Those two are quite difficult to prove. Not that it hasn't been, but so far Malaysian history, it's only one case of an arbitration, but
Rare.
Very rare indeed.
So
Worldwide
feeling
also.
pretty safe.
Yeah, pretty safe.
What about in Hong Kong?
I'm afraid to say that our mediators are not covered by immunity. If you are not working in a law firm or even a barrister, the chances are you need to buy professional indemnity insurance. In Hong Kong, buying professional indemnity insurance is not cheap. Okay, so the chances are most people were attached to some organization in UK, and usually they can actually have a worldwide cover, which is much cheaper. But for those who are doing adjudication, even for example, or even arbitration, if you get immunity, I would suggest you still have PI insurance, because when someone starts a claim, a case against you, you still have to actually engage people to do the work. The insurance companies will not pay straight away, so it takes time. So if a solicitor like Nick asks you for a deposit, you can't go to the insurance company and say, can you pay me a deposit to pay Nick? Because the insurance company will take some time to actually do the process, so you need to take out some money yourself. So that's why, for example, you have to be aware of this as well. So there's quite a few things that you need to be aware. And I think the key thing is most people tend to get challenged on is you haven't followed the procedures properly. Because sometimes as engineers, I used to be an engineer, we tend to follow procedures very clearly. So that's why for those who are in a different profession, they don't follow procedures properly, I would suggest you follow them very clearly. The rules are very important. If the rules and the law conflict, then the law will prevail. So the chances are, if the rules are saying that you have to deliver things within a certain time frame, if you don't do it, then basically then that could be a problem for you as well. You as an adjudicator are supposed to deliver your decision within a certain time frame, and if you don't, then it's basically cannot be enforced in terms of the court, and that will create a problem for you as an adjudicator, because the client might turn around and sue you for negligence as well. So even they might want to take an action against you.
Would this deter people from wanting to be adjudicator?
I don't think it will deter people from wanting to be adjudicated, because everyone wants to be righteous in the world. Everyone wants to be a decision maker. Everyone wants to be seen to be giving the right decision. They want to help people. I think that's important. But the key thing is, don't always assume that you know everything. I always take this attitude that CPD, continuing professional development, is very important, because I'm always learning. I'm doing another degree at this moment in time. Why? Not in law, not in engineering, something totally different. Why? Because I don't know that area, and I want to learn from that area. If you are not familiar with that area, the chances are always learn from others. At the end of the day, you, as the judge said, Steve Jobs and all these different people, they do have wisdom. They actually have experience of dealing with different areas. So chances are, if you learn from them, you actually become a better person. And don't be afraid of making mistakes.
Can I just share?
Yes.
Under
Justice.
our statute, and you might want to look into it, an adjudicator who delivers his decision past 45 days from the date of the reply being filed by the non-paying party renders his own determination void. In other words, his determination has no value, not worth more than the paper it's written on, because our statute says it is void. It can be just 1 second or 15 seconds past midnight. If it is past 45 days, it's void. And let me tell you from experience, because we have cases coming before us where decision of the adjudicator has been sought to be set aside, and we ask why. It is delivered out of time. And we ask ourselves, why is that so? Oh, because that adjudicator actually cut it right to the very age, and he forgot that perhaps in his letterhead, working hours is 9 a.m. to 5 p.m. Anything served after 5 p.m. is considered served the next day. And when it comes to definition of working days, it is the working days of the project site. In other words, we have something like 14 states in Malaysia, and so, it depends on where the holiday is. And sometimes it is holiday in KL, it's not holiday in Selangor, and you are based in Selangor, and you calculated the days wrongly. So if you're an adjudicator, give yourself a leeway, a buffer of at least 5 working days, so that in case you count arithmetically incorrectly, your whole decision does not become void. Then you ask yourself the question, why can't I avoid this by getting parties to consent to extend my time? Well, at that stage, one party might think that the wind is blowing a certain direction, not in his path. So he might say, no, I don't want to extend time. You finish it within time. And sometimes by the time you ask for extension of time, you're already out of time. So under our law, the court can order the adjudicator to refund back his fees. As to whether or not he could be sued separately, we haven't come to that yet.
Right.
And so there have been cases. In one case, I have to do that, unpleasant task. But I said, you're out of time, and so refund the fees, which the adjudicator did refund. So be very careful. Don't cut too near the edge. Give yourself some buffer.
Good advice. Thank you.
There's so much documents, the chances are you as adjudicator will not have enough time to read it in the 45 days. So I think for those who are actually making claims or even sort of responding to a claim, sometimes have an executive summary, the key areas. So the chances are then the adjudicator can home into those areas and also identify and also have a very good index. Okay, because I did a case whereby they just threw all the documents to me and I had to search every single document and sort of index them all myself. And eventually it took a long time. It took me roughly a whole week to just do that in order for me to actually then read the case and see how the thing works. Chances are that's why sometimes if you want to have a good decision by the adjudicator, the answer is you have to help that person to actually make that good decision. If you don't help that person by giving them lots of information, because sometimes the contracts are so thick, you just dump him the whole contract. But you don't identify which parts of the contract you're trying to focus on. And he has to read through every single point, and the chances are that takes time.
But you have to counter-check because they have been known to conjure up cases with seemingly authentic citation. When you check for it, the cases are not there. And there have been lawyers who have been found guilty of contempt because they misled the judge on cases that are non-existent. So be very careful.
You all kind of commented on the Hong Kong law that's about to take effect soon. Out of 100, how many points would you give the Hong Kong law?
No, I must commend you for drawing the best practices from around the globe where adjudication had been practiced in the field of construction law and adapting it to fit your own local particularities and peculiarities. One or two areas that perhaps you could look into with respect to improving it. As I said, there is no particular statement on the effect of an adjudication determination that is rendered outside the time frame. In your case, it's 55 days from the date of your appointment. So perhaps you might want to look into that. The other area is pay when paid, whether it should extend to other conditional type of clauses. And then one other area is with respect to what I would call the training of adjudicators, because under our jurisdiction, the AIAC is responsible to train, certify, and they have a program for continuing training and development. And so I suppose those of you who want to be adjudicators would, of course, from now till August, prepare yourself for that, because you're supposed to give a reasoned adjudication award or determination. People know at least why you allow that claim and dismiss the other claim. And so it is a good thing to undergo training. I think the last check with AIAC, 6 of the people from Hong Kong are actually registered as adjudicators in Malaysia. You're one of them, is that Dr. Christopher?
Yes, I am.
Have you had quite a few jobs, at least one every year?
I've had quite a few.
Yeah, good.
So time to apply to our sister organization in Malaysia to get some experience ahead of August. Still time. Can I open the floor for questions? Is that anything you want to add for now?
Can I say just one thing on what the judge has said? In society, nothing is perfect, okay? Us as lawyers, we tend to want to challenge. So no matter how the law is written, how detailed it is, we will find a ground to challenge it. And that's why the judges are very good, because they will actually make the law in the sense that once that's been determined, then the chances of further challenges, the chance that will be limited. So I think the first, maybe to second year, we could have a few cases going to court. But after that, once that stabilizes, the answer is less cases will be done. And then I personally believe that the DOJ, Department of Justice in Hong Kong, has been promoting mediation a lot. So I think most of the cases might not even go through the adjudication process. They might just settle on the mediation side. So I think that's hopefully my vision of moving forward.
Thank you. So any questions from the floor? Anyone? Or anyone have solutions about how to facilitate? I mean, there are a couple of people here in the room. I'd like to call on you perhaps to put your hand up to maybe talk about briefly about your payment solution for the construction industry. Is there anything you could do, smart contract, blockchain? I mean, we have the law, but after all, the pain we're trying to address is to really resolve it so money get moved along and people get what they want, what they deserve, and jobs get done. Any comments? Anyone?
If I have one comment, my biggest comment about the adjudication legislation around the world is if you are the respondent, the person responding to a claim, you only have so little time to prepare. And if you're the lawyer external, usually when you ask the client for all the documents, the 14 days to respond doesn't give you much time. So basically all your trainees and associates have to work 24 hours in order to provide a meaningful response to a claim. I was always advocating the 90-day period. Why? Because end of the day, with a 90-day period for the whole process, at least you give the other side, the respondent, a better chance of defending the claim or even putting forward arguments that contradict what the other side's put forward. I think that will be more helpful. But unfortunately, time is of the essence and money and so forth. So people say, okay, we need to cut it short because cash flow is an issue. But I still believe that you should be giving more time to the respondent to actually address the concerns of the person making the claim.
Dato, Justice Lee.
Yeah. In some jurisdiction, like in Western Australia, each time the contractor sends out an invoice, there will be a notation that this is also a claim under the relevant legislation. In your case, will be the Construction Security of Payment Act. And so they get used to it, and after a while, the employers would know that they have to pay within that time frame. But there are also people who, in their payment claim, besides making a claim, would also wish you successful and prosperous Chinese Lunar Year and all the best for 2025, when actually in between is the line to say this is also a claim under your act. And so you have always to be vigilant. Each time you receive a claim, your ordinance and our act says you must have this magical one-liner to say this is a claim under our statute and your ordinance. And it's couched in so many other words, Merry Christmas and a Happy New Year and whatnot, And so you must tell your staff, sometimes things have been timed so that they know that your staff is going to go on leave. And so you cannot, within that 10 days in our case, or perhaps longer in your case, come up with the relevant reply. So the thing is, come August, and in preparation for that, you must always be contractually ready to either go for or defend an adjudication claim. It cannot be that you scurry for your documents when you are served with that. It must be a case of eternal vigilance, if I may use the word.
Get the system in place.
You must always be ever ready, like the Scouts motto. But it's good for everyone, I think.
Fantastic. So a question from the floor.
So I'm Sophia Yep from Chief Legal Officer of HKBM, a telecommunication company. I used to work for CBRE. I was the Asia Pacific General Counsel, so we had lots of litigation, lots of construction issues and all that. So for us in the room, I guess a lot of us are aspiring mediators and adjudicators, thanks to Chris and Nick who's championing this area. Dato says you have to ask smart questions. So how do we equip, like Chris is saying, to equip ourselves to learn more, to ask smart questions? And what are the bad questions we should never be asking from your experience?
I don't know. Each time I listen to an expert witness, I always have this preface. Pardon me if I ask what to you might be a silly question, but sometimes you really need to ask a silly question or what is apparently perceived as a silly question. Because in one case, an architect was asked the question, when is a defect a defect? And he couldn't answer, He had to search for words and try to grope the concepts and whatnot. And so we, as Albert Einstein says, everything is to be made as simple as possible, but not simpler. You don't oversimplify it, but you're entitled to challenge so-called established paradigm. Why is it wrong? why is third-party financing something that is now in vogue, but it had never been all these years? What's so wrong with getting people to fund you for litigation or arbitration or even adjudication? Would it compromise so-called good standards of morality or ethics? And so we always challenge that kind of thing. Those days, solicitors' clients privilege, but what about money laundering? I mean, is there an exception to it? And so we mustn't be afraid to ask so-called established paradigms and principles and then revisit it. And so for expert witnesses, I will always say, pardon me if I were to ask you this simple question, why is it that for a curved bridge, the outside expands faster than the inside, you know? And what are the forces at work, and why does this bridge collapse, you know? And the experts will come up with so many different answers. At one time when the bridge collapsed, fortunately it was just a pedestrian bridge, 3 experts came up with 3 theories as to how the bridge collapsed. So a layman like me scratch his head and then try to find out which is more probable. But we asked the simple questions. And then we try to be able to understand it. Because it's too complicated for us to understand, then you missed persuading us. I'm not too sure whether I've answered your question, but be not afraid to ask the silly questions.
Okay, hand at the back. Thank you.
Hi, I'm Ben, CEO of RiverChain. RiverChain is a fintech startup in the construction space where we make working capital solutions available for SME construction companies. I have a question regarding cases, types of cases that you typically see. So I'd imagine that a lot of cases and claims are on final counts, but there are also potential cases that are in the interim of a construction project. Now, from what I've heard in the sector is that in the interim, they're less likely going to escalate cases because they would lose the relationship with potentially a main contractor or the employer. What are the cases that you're seeing? And in interim cases, how do you advise for subcontractors to take the necessary steps for a proper way of claiming, but also maintaining a relationship?
Thank you, Ben.
In our context, we find that a lot of claims are actually progress claims. But there are also some contractors who take the view that I don't want to spoil relationship. The moment I go for adjudication, it's like my employer is not going to talk to me anymore. There is just tension each time I go into the work site, and we can't communicate anymore because we start erecting barriers, you know. But our case law have stated that adjudication applies also to final accounts, claim, etc. And so very much depends on the kind of dynamics between the contractor and the employer. Some would say, nothing for you to hold grudges against me, nothing personal. It is just that our policy is when we put in a claim, we also say this is also considered a payment claim under the equivalent of our statute, or it means as you pay us within 30 days, that's all, you know. So it all depends on the culture that you have to finally cultivate and communicate to your employer. But I reckon that in some instances, there are employers and there are employers, and some would say the moment you shoot me a payment claim, that's it. Don't talk about future business with me, and currently life becomes hell for you. And so much depends on how much they need your expertise, how far into the project the work has proceeded, etc., etc. So it's difficult to predict how someone would react or respond to a payment claim. But strictly speaking, if it is for work done, there is nothing to be ashamed of. If you can hold on, you hold on longer. If you really can't, you have no choice. Because your employees have to be paid, your suppliers have to be paid, otherwise they will insist on cash on deliveries. We won't give you any credit terms. So it all varies from parties to parties, but hopefully we'll create a culture where people will look at adjudication as just an interim kind of measures taken while the project is ongoing. It is not that I don't like you anymore, or that I'm not towing the line, or that I'm going against you. It is that my contractors and workers needs to be paid. That's all.
You look at the Hong Kong experience or Malaysian experience, who pays for the adjudicators' fees? And is it done fairly here? How do you see?
Here both contribute equally at the start, but at the end of it all, when you lose, the loser will have to pay the winner's adjudicators' fees. Yes.
Great. Any questions from other friends in the room?
Could I just, Nick, address that gentleman's point? I think Daniel Lam's here.
Yes.
So I'm not trying to put Daniel Lam in a position, but I think Daniel Lam remembers...
Microphone to Daniel, please.
Yeah, Daniel remembers the Henry Tang report. Remember that? The Henry Tang report said very clearly that there were adversarial sort of cultural aspects in terms of claims. And we need to change our culture, sort of our philosophy in how we actually address claims. Now, without doubt, if you put forward a claim against an employer or even a main contractor, they're going to have this perception you are a troublemaker. And that's why we have different ways of resolving disputes. That's why I said early on, not a lot of cases might go to adjudication. They might just settle on the mediation side because they want to maintain that relationship. But for those who are one-off contractors who want to actually just get the money to pay off their other sort of employees, they might just go for adjudication straight away, rather than go through the whole process of sitting down, negotiating, mediating, and so forth. So I think it relates to the dynamics of the different relationships between the parties and also what they want to do going forward. Am I correct, Daniel?
Thank you. Daniel Lam, I'm an arbitrator in private practice. That was 24 years ago when I was sitting as a member of the Construction Industry Review Committee. That followed after a lot of incidents, a heavy incident of short piles. At the time, we were considering how we can make the industry better. We had so many incidents. And 24 years ago, when we did the committee, we finalized with 113 recommendations. And up to today's day, if I look back on the recommendations, less than 50 has been implemented. Now the rest, there must be a lot of reasons. One of the payments would be one of the problems. So I think we need a cultural change for the industry, which we hope to have 24 years ago. Up to today's day, we don't have an overall cultural change. The change is you ought to pay, and the people who execute should be execute the works and supply the materials properly. I remember one of the biggest issue is whether we can have an open book. At the time we talked about, there was a case about British Airways opening up their books and selecting amongst selected contractors and say that in the coming 10 years, we will have so many projects. So you don't worry about lack of projects. You do your investments into machinery, whatever. And then each will have a fair share of the cake. And we talked about it in the committee, but eventually we cannot decide to recommend something like open book working with contractors, because the major reason at the time was all our contractors 24 years ago in Hong Kong, they have more than 3 books, one for tax paying, one for operation, and one for the listed company. So that's a problem. And I think we are moving towards a better society, but still a long way to go.
Digital ledger, blockchain, smart contract could help a little bit. But thank you, Daniel. Any questions from this side of the room? You've been, yes, microphone please.
My name's Hao. I'm a construction lawyer with Herbert Smith Free Hills, Hong Kong office. So this question for Christopher and also the others from the Development Bureau. I'm just wondering, is there any timeline as to whether the 4 A and Bs will be holding the adjudicator accreditation training from now before until the the effective date of the ordinance.
So would the 4 nominating bodies hold training?
I can only speak for the engineers, okay? I can't speak on behalf of Development Bureau because the Development Bureau wants to make sure this is workable, okay? If it's not workable, and the chances are the industry, the consumers don't like it, it could be another thing that people say, wow, another white elephant in the audience. So they have to get the people trained up. So there is a timetable within the engineers that we have to do retraining. So those on the panel will have to come back and do a refresher course, which is free of charge. We just let you know, those engineers in the room, so that you learn about what the legislation is all about. And on top of that, you'll learn about the 4 guidelines that are going to be implemented in terms of, for example, what you need to be aware of. One of them relates to, is very strongly, is about conflict of interest. Because Hong Kong, like Malaysia and Singapore, we are very sort of a small community in terms of constructions. We know each other very well. So things about conflict of interest, what do they really mean? And I think we're trying to use, I think Gilbert Kwok asked me the question last week about whether IBA will be allowing us to use the red, orange, and green, the code of ethics within the Hong Kong context. So I've set them up with the person in New York to actually look into this. So you can see that these are the things that we're doing. And saying that, in our committee, we have a construction and dispute resolution committee. Some members of our institution have said, we want to get involved. So we now have to plan, hopefully, some training courses as well. So we're hoping to do the training courses between April to June in order to cater for the August deadline. So that basically, once someone comes to us on August the 28th to make an appointment, at least we know exactly who do we appoint. We have a system in place. We're now recruiting an assistant lawyer, sort of a general counsel, to assist us in managing these matters. So hopefully we have a very unique system in HKIE. So surveyors, I'm sure they do the same. We work very closely with surveyors and the architects. But I must say this. I did advocate to the Construction Industry Council to provide some funding to these 3 bodies so that they can actually have the funds, seed money, to set up the framework. But the Construction Industry Council at the time said no, they should do it themselves. So that's why now we're scrambling in HKIE to find funds to support this, likewise surveyors, likewise architects as well. So you can see that we are going beyond our needs to actually satisfy the government as well as the community's needs, because we do want to make sure that this system works. Does our friends from the Development Bureau want to say anything about the timelines? They don't want to commit, okay? So end of the day, they have to be sure that the system is good, okay? If the system's not good, the chances are we don't want everyone to criticize, that's all.
And with that, I'd like to close by thanking Justice Dato Lee and also Dr. To, to each and every one of you, and also our supporting organizations, the Law Society of Hong Kong, the Hong Kong Bar Association, Hong Kong IE, Hong Kong Institute of Surveyors, the Hong Kong Institute of Architects are supportive, but we haven't had the time to put it on, I'm sorry. And the Federation of Hong Kong Industries. And thank each and every one of you for coming. I'd like to present a little souvenir as a memento for a friend who come all the way from Malaysia. And if Dr. To don't mind, we'll also present one for Dr. To. And then, thank you. Then we'll close by doing a group photo outside. If you want to exchange business cards, we can continue.